Advocacy at 8. I am attorney Sandra Jill Poland, your community legal advocate. Advocacy at 8 is my new YouTube legal series, which launched yesterday, October 1st, 2018. This series of legal education videos will be posted daily at 8 p.m. Each video, in 8 minutes or less, will educate you on an important legal issue. You and your community at large will be enlightened and empowered. Thank you and your community for viewing Advocacy at 8. I am attorney Sandra Jill Poland, your community legal advocate. Today's topic, trust. Before we continue our discussion on trust, I want to distinguish between wills and trusts. What's the difference between a will and a trust? Well, a will goes into effect only after you die. A trust can take effect as soon as you create it. A will is a legal document that directs who will receive your property at your death, and it appoints a legal representative called an executor to carry out your wishes. An executor is named in the will by the person who creates the will. If there is no will, then the court appoints an individual called an administrator to manage the decedent's estate. The role of the executor, again named in the will by the person who creates the will, and the role of an administrator that's appointed by the court if the decedent leaves no will, those jobs are basically the same, which is to manage the decedent's estate, pay the debts, and distribute the assets. The advantage is that when an individual takes the time to plan their own estate, they get to select the person they want to manage that estate. They don't leave it to the court to determine who it is that's going to manage their estate. That's why, as an advocate, I advocate for you to be proactive to do the estate planning. Wills and trusts are both instruments used for planning. Planning how you would distribute your assets to your beneficiaries. And we defined assets and beneficiaries in our video yesterday evening. If you have spent your life being a good steward over your gifts, talents, and opportunities, and you've accumulated a significant portfolio of assets, then you owe it to yourself to organize your assets in the best way so that you can effectively distribute your assets to your beneficiaries, and they can use those assets in the best way, the most effective way, that's tailored to their skills and tailored to their level of expertise. Why spend 50 years accumulating a significant portfolio, a significant estate, and then distribute them to your beneficiaries, and your beneficiaries go through your assets in a short amount of time? That is counterproductive, and that is not wise. You've spent 50 years wisely using the gifts and talents that you've been given. Then you must take it a step further and preserve your legacy, preserve that wealth, and establish the most effective estate plan possible. That's why trusts are so flexible. They have parameters. You can create conditions. They're suited specifically for the beneficiary's needs, level of expertise. You can establish a trustee to oversee the distribution of assets. They're a very creative legal document. As we said yesterday, trusts are a fiduciary relationship where one party, the trustor, gives another party, the trustee, the right to hold title, property, or assets for the benefit of a third party, the beneficiary. Trusts are established, one, to provide legal protection for the trustor's assets, two, to make sure those assets are distributed according to the wishes of the trustor, and three, to save time, reduce paperwork, or in some cases, avoid or reduce inheritance or estate taxes. A trust can be used to determine how a person's money should be managed and distributed while that person is alive. That's called an inter vivos or a living trust. Or the trust can be a testamentary trust or a will trust, which takes effect after the person's death. A trust can help avoid taxes and probate. It can also protect assets from creditors. There are two main categories of trust: a living trust and a testamentary trust. A living trust, also known as an inter vivos trust, is that written document in which an individual's assets are provided as a trust for the individual's use and benefit during her lifetime. A testamentary trust, also known as a will trust, is a written document that details how the assets of an individual are distributed after the individual's death. Living trusts can be revocable, which means they can be changed or terminated during the trustor's lifetime, or they can be irrevocable, which means they cannot be changed. A testamentary trust, one that is effective after the death of the creator of the trust, by its very definition, created to take effect once the trustor is deceased, is irrevocable and cannot be changed or terminated. An irrevocable trust is usually more desirable. Why is that? One, it's unalterable. It cannot be altered. And two, it contains assets that have been permanently moved out of the trustor's possession. Now, why is it better if a document cannot be altered? Well, you don't have to worry about somebody coming along afterwards and sort of modifying the initial document. Once it's done, it's in stone. And so therefore, there's a little bit more security with that kind of document. The second benefit is that because it's irrevocable, then the trustor no longer has control over those assets. It's moved out of the trustor's possession, out of the trustor's estate. That's what allows the estate taxes to be minimized or avoided altogether. Now, why is that? Usually, estate taxes are based on the value of the estate. So if there is an estate that is worth $1 million, there's going to be more taxes attributed to that estate as opposed to an estate worth $50,000, lower taxes. Smaller estate, lower taxes, estate taxes. So let's say you have an estate worth $1,050,000. But let's say out of that $1,050,000, $1 million in assets is removed from that estate and put into a trust. Then the estate only has $50,000 left. Well, $1,050,000 estate is going to be taxed at a much higher level than a $50,000 estate. So far we've categorized trust in two ways. First, whether they are created by the trustor to be effective during the trustor's life, a living trust, and then after her death, the testamentary trust. Tomorrow, we'll talk about a third way to look at trust, funded or unfunded. Thank you so much for spending time with us at Advocacy at 8. See you tomorrow.